I now give the floor to Professor Philippe Sands. You have the floor.
Mr. President, members of the court, you've now heard the first round of both parties in this case, and the witnesses and the expert. In these submissions, which introduce the second round of the Gambia's oral arguments, I'm going to address some of the bigger picture issues that are in dispute. I'll focus on the Genocide Convention and the role of this court as the principal judicial organ of the United Nations. First, the Gambia maintains the totality of its arguments. Nothing we have heard from Myanmar causes any change in our position. Quite the contrary. It is clear that Myanmar offers no real challenge to the essential facts, namely that huge numbers of Rohingya have been subjected to the most terrible atrocities: killings, rapes, brutalization, beatings, destruction of homes and villages, destitution, being driven from their lands and across the border into Bangladesh. Those of us in this great hall who attended the hearings in the Bosnia and Croatia case are bound to recognize that the nature and scale of the acts in this case are notably different. The fact of wrongdoing and the criminality on an industrial scale is not in issue. What is in issue is the characterization of those facts in law. Second, against the background of such terrible facts, Myanmar's options for argument are limited. We all heard Mr. Hooper acknowledge to witness MS that atrocities have been committed. Myanmar's strategy is therefore plain for everyone to see. 1. Challenge the probative value of the body of evidence before you, the manner of its collection, form, reliability, and 2, argue for an unattainably high bar for proof of intent to destroy the group in whole or in part. And as predicted, the approach of Myanmar truly was Dickensian, attacking the Gambia's arguments with 1,000 cuts, salami slicing away, taking you deep, deep, deep into minutiae in the hope that those who are listening will no longer be able to see the wood from the trees. It is indeed bleak house. Did you not at times feel, as we were taken village by village by village, that you were being ground to bits in a slow mill and then roasted at a slow fire? Not once, not twice, but 3 times and more. For no more than grains and drops of dispute, they argued. And as I listened to their counsel, it struck me as striking how they failed to address the bigger picture. There was no attempt to explain the pattern of conduct in relation to the crimes. No attempt to explain why villages were bulldozed after they were burned to the ground. No attempt to tell you why fleeing children were shot dead. No attempt, literally nothing at all, silence, to respond to the expert reports, 2 of them, of a retired, decorated US Army Lieutenant Colonel who on the basis of those reports told you in the very plainest of terms that what you have before you is not ethnic cleansing or war crimes, and that Myanmar's conduct can only be explained as the expression of an intention to destroy a part of the Rohingya group. Professor Newton's testimony is completely unchallenged. Which brings me to a third point. Beyond the parties' arguments on law and fact, you've now heard from witnesses. You've had a chance to question them, to assess for yourselves their credibility and their reliability of the first-hand accounts of what befell them. And that evidence shows clearly that the particular circumstances of the village from which they came was genocide. Witness MS offered a harrowing account, one that included the murder of his wife, 5 of his 6 children, and 56 close relatives in the village of Mingi. His account of the facts was not challenged. And you saw for yourselves in this courtroom the continuing consequences, the serious mental harm caused to one member of the Rohingya group within the meaning of Article 2, Paragraph B of the Convention. Imagine his testimony repeated tens of thousands of times more. Witness NJ offered no less devastating an account. You heard from her directly of the deaths of her husband and her father-in-law, how one of her children was taken from her arms and murdered by being stabbed and then thrown into a fire before her very eyes. And you then heard how she was gang raped. You heard too from her of the discriminations to which she has been subjected. No freedom of movement, no education, a mass of restrictions and humiliations, no citizenship card, all imposed by the Myanmar authorities, and then confirmed and elaborated in response to the questions put by Judge Sepudinde. Cross-examination by counsel for Myanmar made no dent whatsoever. And witness MN's account was equally horrifying. You heard directly how this man, a teacher, was part of a large group of men, 87 in number, he said, separated from their families in the village of Mongnao, taken to another place, and then executed. He was the only survivor. And for this reason, as I listened to his account, what came to my mind was another account of a mass killing, also told by a teacher, one that was written about 80 years ago. His name was Gershon Tafet, and he wrote of a massacre in a small town called Żółkiew, then in Poland, today in Ukraine. And like witness MN, Gershon Tafet was the only survivor of a genocidal act that took the lives of the uncle and many family members of a man whose portrait hangs in the judge's reading room in this court's new wing, Judge Hirsch-Lauterpacht. I mention this because that act of killing, evocative of what we have heard from witness MN, was precisely of the kind that inspired the drafting of the 1948 Convention on the Prevention and Punishment of Genocide. And contrary to what Counsel for Myanmar told you, there is a direct line that connects then and now, and that feeds into the role and responsibilities of this court today. After the witnesses, you heard from Professor Newton, an independent expert, that's not an issue, who has provided reports and an affidavit for the court and whose testimony is unchallenged. Under cross-examination by counsel for Myanmar, you'll have seen for yourself the care and diligence with which he carried out his tasks and the clarity and the authority of his conclusions. He made crystal clear, not least in response to some of your questions, that any suggestion that the atrocities described by the 3 witnesses and acknowledged by Mr. Hooper cannot possibly be explained as a mere excess in legitimate counterinsurgency exercise or an exercise in ethnic cleansing. The argument is a sham, he said, of the counterinsurgency claim, and he made very clear why. I can do no better than remind you of Professor Newton's words, and I quote, "I'll give you the modus operandi again, which is absolutely indicative of an intentional, coordinated series of attacks directed against that portion of the population, surprise attacks, no notice, no warning, often from multiple angles, indiscriminate shooting, no effort whatsoever to determine an ARSA location or an ARSA house or a safe house or an IED factory, no cordon and search operation, followed by segregations and executions, followed by mass extermination, the same pattern over and over and over. Extermination, shooting at refugees, mass rapes orchestrated, followed by the burnings and the bulldozings. Counterinsurgency? I don't think so. Ethnic cleansing? Try explaining that in your judgment. The witness and expert testimony you have heard is fully conclusive of the facts on pattern of conduct to which they attest. It is fully conclusive. And let's use the French language because it is slightly different. Ayant pleine force probante. These characterize what happened in the particular circumstances and what happened in scores of villages as genocide. These were not killings like Maillet or Haditha, one-off war crimes. Nor were they, as Professor Newton made crystal clear, ethnic cleansing, which is a crime against humanity. It is not ethnic cleansing, Professor Newton told you, because ethnic cleansing does not involve mass rapes with ethnic slurs, or babies killed and thrown into burning houses, wells and rivers, or the killing of the children of a particular group, or the slaughter of men, or shooting at fleeing refugees, or sinking boats. This is not just ethnic cleansing. Retired Lieutenant Colonel Newton of the US Army told you. It is fully conclusive of the existence of a pattern of conduct, one that gives rise to the only reasonable inference, conduct intended to destroy the Rohingya community in parts of northern Rakhine State. I turn to the Genocide Convention. First, a few general comments, and then some specific ones on burden and standard of proof. Contrary to what Counsel for Myanmar said, the genesis of the 1948 Convention is important, and it is relevant to the treaty's interpretation and application in this case. After Nuremberg, when the judgment failed to mention the word genocide, Raphael Lemkin almost single-handedly procured Resolution 96-1 at the UN General Assembly's first ever session. The resolution affirmed that genocide is a crime under international law, and the resolution requested the UN Economic and Social Council to draw up a convention. That convention was concluded in December 1948 in the session held at the Palais de Chaillot in Paris, just as Jean Cocteau's films Les Parents Terribles opened in the local cinemas. The UN General Assembly is the decent parent of the 1948 Convention. To be sure, the Convention does not include everything that Lemkin wanted, like the protection of social groups or culture. But to all intents and purposes, it is fully a reflection of the ideas he set forth in Chapter 9 of Axis Rule. And for the rest of his life, 11 years, Lemkin devoted himself to lobbying countries to ratify the convention. And 3 years before he died, in relation to Myanmar, he succeeded. The writ of the convention was limited until the mid-1990s. And then came the terrible events in the former Yugoslavia and Rwanda. The UN addressed those moments by creating two international criminal tribunals, and their work provided a jurisprudence upon which this court could rely in the Bosnia and Croatia cases. In this case, you do not have the jurisprudence of an ICTY to turn to, or any other judicial body that has gathered and tested the evidence. But do not say we have nothing, to evoke the title of Madeleine Thiem's prize-winning novel. In fact, you have a great deal, and it is highly significant, and it is probative. For the UN General Assembly and related UN bodies have actively and effectively fulfilled their mandates in responding to the allegations of atrocities in Myanmar once they began to filter through. By Resolution 3422, on 24th of March 2017, the UN Human Rights Council responded by creating an independent international fact-finding mission, the FFM, to establish the facts and circumstances of what was going on, the horrors. The resolution was adopted by consensus. 3 individuals were appointed to the FFM, highly experienced lawyers, each of them, from Sri Lanka, from Australia, from Indonesia, led by the former Attorney General of that last mentioned country. They spent 15 months assisted by a highly professional team. They gathered evidence, including 875 witness testimonies, and they wrote a first 440-page report. Published on the 12th of September 2018, it concluded that the crimes in Rakhine State were perpetrated with genocidal intent, having regard to, and I quote, the jurisprudence of international tribunals regarding the reasonable inference of such intent. All other possible inferences regarding intent were discounted by the FFM as unreasonable. The UN FFM would go on to produce a second report in September 2019, another 419 witness statements. Its conclusion that the remaining Rohingya lived under a continuing threat of genocide, and Myanmar was failing in its obligation to prevent genocide, to investigate genocide, and to enact effective legislation criminalizing and punishing genocide. In the meantime, the United Nations Human Rights Council adopted Resolution 39.2 to establish an independent investigative mechanism for Myanmar, the IIMM. And this would gather evidence of the most serious international crimes and violations of international law committed in that country since 2011. It's gone on to collect still more witness evidence, some of which is before the court. In January 2019, the UN General Assembly adopted Resolution 73-264. It expressed grave concern at the findings of the FFM, and I quote, that there is sufficient information to warrant investigation and prosecution so that a competent court may determine liability for genocide in relation to the situation in Rakhine State. These resolutions and their fruits and the work of the IIMM are what in turn catalyzed the Gambia into bringing this case to a competent court. And that court is you, offering you the duty and the responsibility to assess and take forward what has been done by a raft of UN bodies, the General Assembly, the Human Rights Council, the Fact-Finding Mission, the IIMM. The Gambia has relied on the work of the United Nations to bring this case to the principal judicial organ of the United Nations. And after the Gambia brought the case to this court, the UN Human Rights Council acted again. By Resolution 4326, it welcomed this court's Provisional Measures Order and called for the IIMM to cooperate in a close and timely way with this court. And the IIMM has so cooperated. It has provided 42 witness statements to the parties, 31 of which are formally submitted in these proceedings. And the head of the IIMM, a lawyer with first-hand experience in the work and prosecutions of international criminal tribunals, he knows what he's talking about, has submitted an affidavit to this court. Why do I refer back to this history? Because it is relevant to the role of the court and to your role as judges. The preamble to the 1948 Convention called for international cooperation to liberate the world from the odious scourge of genocide. And this case is a consequence of that cooperation. This court is at the end of a pipeline that connects the parties to the 1948 Convention with the UN General Assembly and the Human Rights Council, as well as the FFM and the IIMM. And finally, we arrive at the court. In the case of the Rohingya, the court may not have an ICTY to turn to, but it has evidence collected by UN processes established as part and parcel of a deep and long-standing United Nations effort at accountability, one that was directly sanctioned by the General Assembly. So, is this court going to say that the UN has given you nothing, or that what it has given you is somehow inadequate? No. You have a massive evidence, and it emanates from UN sources that are independent and authoritative. And that's what gives it a particular weight, which Mr. Reichler is going to come back to in due course, because the court is the UN's principal judicial organ. Myanmar's argument that you should reject that evidence would demolish the system of investigation and accountability set up by the United Nations. And so we adopt the view expressed by the 6 interveners, including France, and Germany, and Canada, Belgium, and Denmark, and the United Kingdom. And I quote, reports generated by the United Nations, such as reports produced by the fact-finding missions, commissions of inquiry, and reports that the Secretary-General of the United Nations may prepare for the UN Security Council or General Assembly, can have special importance. Indeed, such reports can be particularly credible because they emanate from a disinterested witness, namely one who is not a party to the proceedings and stands to gain or lose nothing from its outcome. Special importance, particularly credible. Let's hear what Myanmar has to say about that. There's perhaps another aspect that is relevant. In its Provisional Measures Order of 23rd of January 2020, the court did refer to General Assembly Resolution 73264, and it did place reliance on the detailed reports of the UN FFM. In another case before this court, one of the judges addressed the FFM reports and explained how they were relied upon in these proceedings, in this case, how the court, quote, examines at length and eventually declares plausible the existence of genocidal intent, end of quote. And that judge proceeds to explain how, and I quote, based on these findings regarding genocidal intent, end of quote. I'm referring there to the findings of the FFM, and I quote, that the court considered the rights under the Genocide Convention to be plausible. In other words, this court has already determined by a unanimous decision that evidence of genocidal intent in this case has crossed the threshold of plausibility. What remains is whether, now that the court has studied the extensive written pleadings and heard the oral arguments, whether the court is fully convinced that genocide has been committed. Now, what all of this means, in effect, is that this isn't just a case of the Gambia versus Myanmar. It's actually a case of Myanmar versus the United Nations. For the purposes of Myanmar's council last week was to attack all the work done by every single one of these UN bodies. And of course, those council know, they well know, that if this court accepts that work and relies upon it, then they lose. And that is their fear. And that is why they devoted a huge amount of effort to attacking the reliability and authority of the work of the FFM and the IIMM, which will no doubt continue in the second round. In dulcet tones and in Dickensian style, they seek to persuade you item by item, grain by grain, that the entire UN exercise is premised on a single fundamental flaw. It doesn't meet the standards of international criminal justice. That's what they say. The argument is completely misconceived, as you well know, because this court has been very clear in referring to what it calls the duality of responsibility with criminal tribunals. The ICJ has no criminal jurisdictions, one of the judges on the court has rightly noted. It is, to use his words, a judicial organ for the adjudication of interstate disputes, and it fulfills a role in the field of state responsibility for genocide. State responsibility, not criminal justice, over which international criminal tribunals have no jurisdiction. As the principal judicial organ of the United Nations, this court contributes in its respective field, the judge notes, to a common objective shared with the criminal tribunals, namely the objective of international justice. And it does so on the basis of its own methods and approaches. As the court put it in the Pulp Mills case I know well, mindful of what it called the volume and complexity of the factual information submitted to it, the court will make its own determination of the facts on the basis of the evidence presented to it, and then it will apply the relevant rules of international law to those facts which it has found to have existed. So the court has a well-established practice on evidence. I have lived through it, with it, for 35 years. It will prefer contemporaneous evidence from persons with direct knowledge, and it will give weight to evidence that has not, even before a litigation, been challenged by impartial persons for the correctness of what it contains. Mr. President, members of the court, that describes the FFM reports. They are not specially prepared. They do not emanate from a single source. They are contemporaneous, from persons with direct knowledge, and they are unchallenged by impartial persons for their correctness. Myanmar is alone. Only Myanmar in the world challenges the findings of the FFM and the IIMM. Myanmar is alone in arguing that the witness statements are untested by cross-examination. None of the interveners supported that argument, and Myanmar has not found a single state that is willing to intervene in support to its version of what should be done. None, not one. Mr. President, I've lived through the cases that deal with the use of force, environmental harms, human rights violations, and so much more. And never before have I heard it said that in order to place reliance on evidence, it has to be tested in that way. And so all of this does come back to the history of the 1948 Convention, which entrusted to each of you as judges a role as guardians of the Convention. And it falls to you as the judges, not to some international criminal tribunal that has not yet been established and will never be established, to ensure that the Convention's obligations not to commit genocide are fully respected. That is your role. I turn to the question of the burden and standard of proof. As regards the burden of proof, there really isn't much of a difference between the parties. The Gambia has the burden of proving the facts to establish breaches of the convention by Myanmar. We have to prove that the Rohingya are a group, and we've done so. In fact, Mr. Staker has stated that, and it's quote, "It is accepted that acts aimed at the destruction of the Rohingya population in northern Rakhine State as such would fall within the scope of the convention, irrespective of whether that population is a part of a protected group or a protected group in its own right." Next, we have to prove that one or more of the acts set out in Articles 2A to D of the Convention have occurred. And we have proved that. The facts described in our witnesses' testimony basically unchallenged. So that's surely not in dispute, as Ms. Jones will tell you in due course. Next, we have to prove that those acts are connected to an intention on the part of Myanmar to destroy the Rohingya group in whole or in part. And we say we've done that, and we're going to return to this important point. What does Myanmar say in response? They say, well, the Gambia has sought to shift the burden of proof. We have done nothing of the sort. Nor have we sought to argue, as their counsel claims improbably, for some sort of a presumption in favour of genocide. No. What we have done is note that in the face of the FFM reports and the mountains of evidence in support of the proposition that Myanmar intended to destroy the Rohingya group, Myanmar has sought to persuade the court that its actions were motivated by other intentions or motives. The only other motive it has put forward is that it was acting in exercise of counterinsurgency. Professor Talmon told you that if that intention was established, then the intention to destroy could not be established as the only reasonable intention. But he was contradicted by his own colleague, by Mr. Staker, who said to you, and I quote, these are important words, very important words, "Myanmar also accepts that genocide can be committed during a counter-terrorism or counter-insurgency operation." End of quote. Professor Talmon is wrong. Mr. Staker is right. Myanmar can simultaneously be engaged in a counter-insurgency operation against the Rohingya, as Professor Newton told you it was, and also have the intention to destroy the Rohingya group in whole or in part, as Professor Newton told you it did. The mere fact that Myanmar was engaged in counterinsurgency does not prevent the evidence from pointing to an intention to destroy as the only reasonable inference from the conduct. So what other intentions or motives has Myanmar sought to persuade you of? None. We haven't found any. It has not argued that it intended forcibly to remove the population. It has not argued that it intended to engage in ethnic cleansing. All it has argued is that it was engaged in counterinsurgency. And its counsel, on behalf of Myanmar, have accepted that this purpose can coexist with the intention to destroy. Mr. President, this is a moment to address your question, Judge Gomez Robledo, which was put to Myanmar. Please forgive if we also say something about it. You cited paragraph 163 of the court's judgment in the Pulp Mills case, which mentions the expectation that an applicant in a case will submit the relevant evidence to substantiate its claims, as the Gambia has done. The court continues, and I quote, "This does not mean, however, that the respondent should not cooperate in the provision of such evidence as may be in its possession that could assist the court in resolving the dispute submitted to it." And you then asked, Judge Gomez Robledo, quelles conséquences la Cour?
What consequences should the court draw from Myanmar's refusal to cooperate? with the bodies tasked by the United Nations to investigate the facts relied upon by the Gambia for its allegations, including as concerns evidentiary value and inferences drawn from the application's evidence.
Now, we say that is a pertinent and important question. What consequences are to be drawn from a state's failure to cooperate? This question highlights the role of the United Nations bodies in the issues before the court in this case, in their fact-finding role. This question illuminates for us a truth that by its failure to cooperate at all with these bodies, by its failure, for example, to allow those UN bodies to carry out site visits or investigations, Myanmar has undermined its ability to challenge the probative value of the evidence generated by the FMM and other bodies. And it has also undermined its ability to challenge the inferences that those UN bodies have drawn from the facts that it has found, from the evidence it has collected, including the conclusion of the 2019 FFM report, namely, and I quote, "There is no reasonable conclusion to draw other than the inference of genocidal intent from the state's pattern of conduct." End of quote. Don't cooperate. It's pretty tough to challenge those words. Mr. President, I turn to the standard of proof. Now, the standard of proof we've relied upon is precisely the one that the court has told us to rely on in other cases under the 1948 Convention. The proof of the facts has to be fully convincing. You have to be fully convinced that the Rohingya are a group, and I have no doubt that by now you are. You have to be fully convinced that members of the group have been killed, subjected to serious bodily or mental harm, subjected to conditions of life calculated to bring about its physical destruction in whole or in part, or subjected to measures intended to prevent births within the group. It would be odd if by now you are not fully conclusive on that issue. You saw and heard the three witnesses for yourselves. And you have to be fully convinced that the only reasonable inference to be drawn from the evidence and the conduct it discloses is that Myanmar intended to destroy a part of the Rohingya group. The UN bodies are so convinced. Professor Newton is so convinced, as you heard. So that raises the question, no doubt, in your minds, what does fully convinced mean? It means fully convinced. It does not mean, and the court has never said it means, beyond a reasonable doubt. That latter standard is a common law standard, and it's a criminal standard. And this is not a common law court, and this is not a criminal court. The court applies international law, and the international standard to be applied is fully convincing, ayant pleine force probante. This is the moment to address a question put by Judge Hamoud. Sir, you have noted an apparent contradiction in the position adopted by Myanmar. On the one hand, it recognizes that the regimes for individual responsibility and state responsibility are distinct. On the other hand, it goes on to say there's no distinction between a criminal standard of proof and a civil state responsibility standard of proof. That is a contradiction. They are wrong. There is a distinction. First, this court's standard of fully conclusive, as I've said, is not the same as beyond reasonable doubt. Myanmar says they're comparable. Well, what does comparable mean? Well, I checked with the Oxford English Dictionary. Comparable means able to be compared. So sure, you can compare the two different standards, but it doesn't mean the word comparable, that they are the same. They're not the same. In assessing the circumstantial evidence that establishes the genocidal intent as the only reasonable inference, this court asks itself whether the evidence is fully conclusive. A second difference, sir, in relation to your question, this court is not deciding whether any individual is guilty of the crime of genocide and whether they should be deprived of their liberty for that reason. And that necessarily means that the degree of scrutiny will not be the same, will not be as acute. The consequences will not be as dramatic. No one's going to jail because of the judgment you give. Third difference, and relatedly, this court is not asked to form a view as to whether any particular individual had at a particular moment of time a genocidal intent. No, that's not what you're doing. You have to form a view as to whether a state of mind, a genocidal intent, may be attributed to a state by reference to the actions of its organs. In this case, its military forces. The intent of an individual is not the same thing as the intent of a state. And fourth, and again related to this last point, it is not a precondition of state responsibility for genocide that there should be a finding that any person acting on behalf of the state should have committed the crime of genocide according to a beyond reasonable doubt standard, as Myanmar says, or indeed any other standard. Your case law adopts a very different approach. By way of example, this court can determine that a state has been engaged in an illegal use of force without determining that an individual crime of aggression has occurred. That's what you did in the Democratic Republic of Congo versus Uganda. And relatedly, in the Corfu Channel case, the court found that the laying of a minefield, and I quote, could not have been accomplished without the knowledge of the Albanian government, end of quote. In other words, the court formed a view as to the knowledge of Albania. It examined the state of mind of a state, an incorporeal entity, and it did so explicitly by means of indirect evidence, proof drawn from inferences of fact. The court went through this exercise without having established or even being informed about a view on the role or state of mind of any individual or the criminal liability of any person. In short, in its practice, the court has accepted that assessing the state of mind of an individual, the knowledge, whether it's knowledge or intent, is a distinct exercise from assessing the mind of a state. If this court can determine that a state is responsible for the consequences of laying a minefield, it can determine that a state is responsible for the consequences of acts by its armed forces that amount to genocide. And finally, sir, in relation to your important question, which I found very helpful, there is a difference of process in determining whether the applicable standard is met. In the criminal context, there will be weeks, months, years of witness testimony. This court applies its own approach, and it doesn't follow that approach, and consequences must flow from that. So what does fully convinced mean? What does ayant pleine force probante mean? I appreciate that people like me who are trained in the common law sometimes have real difficulty in grappling with civil law or other standards. I sit on the Court of Arbitration for Sport, and there the applicable standard of proof is derived from a Swiss law standard, and for an English barrister it's pretty odd. It's a standard of conviction intime, sometimes translated, not perfectly, as comfortable satisfaction. Well, the first time I encountered this standard about 13 years ago. I must confess I had some difficulty because I'd not encountered it. I'm trained in the common law, and so my brain is totally malformed by these common law conceptions. But then a Swiss lawyer helpfully explained conviction intime to me as follows. If you wake up in the morning and you're still worrying about whether the standard of conviction intime has been met, then it has not been met. When it's met, you don't worry about it. The fully convinced standard is not what makes you comfortable when you make up in the morning, but neither is it susceptible to a mechanical approach. It is for each of you, individually, guardians of the Genocide Convention, to form a view as to whether you personally, in exercise of your judicial function and intellectual capacities, are fully convinced by the evidence in relation to a particular factual matter. It means more than partly convinced, and it means less than totally certain. It's a matter of individual appreciation, and each of you individually will form a view as to whether you are fully convinced that the only reasonable inference from the pattern of conduct, which we say is irrefutably established, is that Myanmar intended to destroy the Rohingya group. And then your individual views will be totted up, added up, and a collective view will emerge. And that is a numbers game. So let me here address Judge Charlesworth's first question, which was for the Gambia. You noted, Judge, that the FFM applied a reasonable grounds standard of proof in making its factual determinations back in 2018 and then 2019, and that the mission described this as lower than that required in criminal proceedings. And you've asked now about the consequence of the application of that standard as compared to the court's fully convinced standard for how the court should approach the fact-finding mission's evidence. Another pertinent question. First off, in any case, goes without saying, but it needs to be said, it's always going to be for the court as a collective to decide whether it is fully convinced by the relevant evidence. Even if the FFM had explicitly applied the fully convinced standard, we would expect the court to go through its own assessment and reach its own conclusions. You're not bound, as such, by factual findings of the FMM, whatever standard it applies, and however credible and authoritative it is, and we say it is both. The standard it applied was that to which it was directed in its terms of reference, in accordance with the practice of UN fact-finding bodies. Accordingly, the difference of standard is, in practical terms, of no real consequence with regard to the exercise you're going to have to go through. That's because you're going to have to go through your own assessment of the facts that were found by the FFM. And doing so, you will form your own view as to how much reliance you feel able to place on the FFM reports. No doubt you'll have regard to the fact the FFM is an independent body, that it's acting pursuant to a mandate given to it by the UN, that it is led by individuals with strong credentials, and that it has applied the stringent UN fact-finding standards that have been in place since 2015. No doubt you'll have regard to the fact that the FFM's mandate did not prevent it from concluding that the evidence reached a higher standard, the court standard, when it concluded, and I quote, that there is no reasonable conclusion to draw other than the inference of genocidal intent from the state's pattern of conduct. You might also have regard to the fact that the factual findings of the FFM have been reached and then acted upon by the High Commissioner for Human Rights, by the Human Rights Council, and by the UN General Assembly. And you might also have regard to the additional evidence that has been put before you, gathered and put before you, which confirms and corroborates the totality of the FFM's findings of facts and its conclusions. And you might have regard to the consequences, including for future work by UN bodies, of this court concluding that the work of the FFM somehow falls short of the court standards. You might have regard to the fact that neither the work nor the conclusions have been challenged by any other state except for Myanmar, and have been received as authoritative across the world. Mr. Reichler will say more about this. But beyond this, you've also been provided with a means to assist in forming your view as to the weight to be given to the FFM's factual findings. 3 witnesses appeared before you to tell their stories and answer their questions, including your questions. And as you listen to what they said in this great hall of justice, did you hear anything that would allow even a shadow of doubt to form in your mind, Judge Charlesworth, as to the conclusions of the FFM reports, on the experiences they went through, and on the matters they addressed and told you about? Were you or were you not fully convinced by witness MN's account of mass execution? Were you or were you not fully convinced by witness NJ's account of having her child torn from her and thrown into a fire before her own eyes? Were you or were you not fully convinced by her testimony about being gang raped? Were you or were you not fully convinced of witness MS's account of his daughter being shot dead as she crossed a river seeking to escape? Did you see or hear any disconnect between these 3 accounts and the facts reported by the FFM? Did you see or hear any disconnect between these accounts and the explanation given by Professor Newton as to why such acts can never be characterized as counterinsurgency and why they are not ethnic cleansing alone? Having all of that evidence and having heard the witnesses, can you say that you are not fully convinced that the acts they described can only be explained as reflecting the intention of the Tatmadaw and Myanmar to destroy them because they happen to be part of a group that has been persecuted and vilified for their race and their religion for decades? Mr. President, members of the court, I turn to the conclusions. By Article 9, the drafters of the 1948 Convention explicitly gave to this court the mandate to resolve disputes relating to the responsibility of a state for genocide. That's what the text says. That direction, that mandate, imposes a burden on all of us in this great hall of justice as we discharge the obligations that fall upon us in relation to the matters of fact and law that arise with this case. And all of us, surely, will have been deeply affected by all the accounts we heard of the witnesses who've spoken in this great hall of justice. But none of us will wish to shirk those responsibilities. At a time when the idea of a rules-based international system faces acute challenge, the weight of those responsibilities may feel very great or perhaps even insurmountable. And that is what makes, at this moment in time, the 1948 Convention so very important. The system that emerged around the Convention has been catalyzed in this case in a way that did not happen in the Bosnia or Croatia cases, which did not have the benefit of a deep, deep dive, a UN exercise into establishing the facts, including thousands of witness statements, generated by an effective, timely, and it has to be said, well-functioning United Nations system. That system may not have prevented the genocide, but it has offered a means to secure accountability for it. And the International Court of Justice, as the principal judicial organ of the United Nations, has been given the central role in securing such accountability. To sum up, the real issue in this case is intent. Myanmar says the intent is counterinsurgency. The Gambia says the intent is the destruction of a group in whole or in part. And so does everyone else who's looked at these issues and facts. The eyes of the world are upon you. Blink, and the 1948 Convention is dead. Mr. President, members of the Court, I thank you for your attention, and I invite you to call Mr. Reichler to the bar.
I thank Professor Sands for his statement.